Hey guys, Eric here with today's LGBT. Again, Eric here with today's LGBT history video. Well, today we're going to dive into a piece of history that happened 5 years ago, and this has to do with the judiciary of the United States. The case was Bostock versus Clay County, and this was about employment discrimination. The Bostock v. Clayton County, 590 U.S. 644 in 2020. The case was heard in 2019, and the decision was handed down in 2020. It is a landmark United States Supreme Court civil rights decision in which the court held that Title VII of the Civil Rights Act of 1964 protects employees against discrimination on the basis of sexual orientation or gender identity. Let me read that again. The court held that Title VII of the Civil Rights Act of 1964, because most people think the only thing that the Civil Rights Act of 1964 did was to put into law the protection of the right to vote for African Americans. That is not all that act contains, which is why it is under attack and trying to be dismantled. But Title VII of the act protects employees against discrimination on the basis of sexual orientation or gender identity. The plaintiff, Gerald Bostock, was fired from his county job after he expressed interest in a gay softball league at work. The lower courts followed the 11th Circuit's court past precedent that Title VII did not cover employment discrimination based on sexual orientation. The case was consolidated with Altitude Express Incorporated versus Zarda, a similar case of apparent discrimination due to sexual orientation from the Second Circuit, but which had added to a circuit split. Oral arguments were heard on October 8, 2019, alongside RG&GR, Harris Funeral Homes Incorporated versus Equal Employment Opportunity Commission, a similar question of Title VII discriminating relating to transgendered persons. On June 15, 2020, the court ruled in a 6-3 decision covering all three cases together that discrimination on the basis of sexual orientation or gender identity is necessarily also discrimination, quote, because of sex, unquote, as prohibited by Title VII. According to Justice Neil Gorsuch's majority opinion, that is so because employers discriminating against gay or transgendered employees accept a certain conduct, such as attraction to women, in employees of one sex, but not in employees of the other sex. The ruling has been hailed as one of the most important legal decisions regarding LGBTQ rights in the United States, along with Lawrence versus Texas 2003, which said that homosexual sex is not against the law. And then Obergefell versus Hodges from 2015, that case stated, got rid of the Defense of Marriage Act, which said that marriage can only be between one man and one woman. Many legal analysts claimed that the case defined Gorsuch as a textualist in statutory interpretation. Now, regarding LGBTQ plus employment protections, until Bostock, whether the Civil Rights Act gave federal protection against employee discrimination to the class of LGBTQ people was in dispute. Individual states since 1973 acted on their own accord to extend employment discrimination protections to explicitly cover LGBTQ employees. And before the Bostock decision, 21 states had included LGBTQ as a protected class against employment discrimination, while other states offered some but less intensive protections in their laws. States with such protections often have a state-level board that performs functions equivalent to the EEOC, which is the Equal Employment Opportunity Commission, and which will work with the EEOC to unify employment discrimination regulations. Numerous local governments passed similar LGBTQ plus employment discrimination statutes as well. Since 1994, members of the Democratic Party in the United States Congress have introduced some form of the Employment Non-Discrimination Act in nearly every two-year term, which would have amended the Civil Rights Act to include both sexual orientation and gender identity as protected classes under Title VII at the federal level, and thus applying across the entire country. Passage of these bills has generally failed because lack of support among Republicans, no surprise there, especially in the House of Representatives. More recently, the Equality Act, expanding the non-discrimination protections to include housing, education, and other areas, was introduced in 2015 and similarly introduced each term, failing to pass to declining support for LGBTQ rights and particularly transgendered rights among Republicans since 2013. Again, no surprise there. Which means for everyday people, a gay couple, say if I had a boyfriend and me and my boyfriend went to, say, let me think of a city that may not have the housing protection. Let's say that I went to Mooresville, North Carolina, and tried to rent an apartment. There really shouldn't be an apartment because the rules are, the policy is, in one-bedroom apartment, the most people that could be in a one-bedroom adults are two. And me and my boyfriend would constitute two, and we would be a couple. However, without that protection, it would not be wrong for an apartment complex to turn our application down for that reason. That would not happen in Mecklenburg County because Mecklenburg County has those protections. But outside Mecklenburg County, it's a little sketchy in North Carolina. That's why it keeps getting brought up every year after year after year when Congress is up for re-election. This is why codification is important. And so, as we contemplate these cases, and particularly this case regarding employment discrimination, that can be applied to what's going on today. The firing of LGBTQ members of our military service, the firing of LGBTQ federal service workers, state workers. These things are real. Not everybody lives in a city or state that has added that to their laws. That's why federal law is important. And so this falls in line with what I always say when I wrap up videos, is that elections have consequences, people. We don't need to go through another finding out phase. We don't. This should be the bellwether moment after this election when everybody and their mother were doing hashtag FAFO because people fucked around, which caused all of us to have to find out in the finding out phase. We don't need to go through this again. We don't. We already know who the players are. We already know who understands what it means to be an American and what it means for this to be a constitutional republic form of democracy, not an authoritarian government, not a Christian nationalist government, and certainly not a government for only white male America. So while you contemplate that this weekend, I'll wrap up this video as I always do. Hashtag elections have consequences. Hashtag midterm elections for 2026. And always remember, resistance is not futile. See you on the next one.